All right, joining me now, CourtTV legal correspondent Chanley Painter. She is in Washington. Also joining us is Seth Berenzweig. He's a trial attorney, and he's out of Washington, D.C. Thank you very much, both of you, for being with me again. And Chanley, let me go to you first and ask, I actually listened to Ted Cruz, and I thought a lot of what he had to say made sense. One of the things he said early on in his statement was that, one thing you're not hearing from the Democrats is about the qualifications of the person sitting there, which is what this should really be all about. And I thought that was pretty straightforward. I mean, at the end of the day, we didn't hear a lot from the Democrats about whether she was qualified. I think it's fair to say she's pretty qualified.
I would agree with that. She seems quite qualified. I mean, graduating from her law school class #1 in her class, Notre Dame, and then she went on to clerk for a D.C. Circuit Court of Appeals judge, and then, of course, Antonin Scalia, former Supreme Court justice for a year before her 15-year stint as a law professor there at Notre Dame before President Trump nominated her to the Court of Appeals in 2017, and she was confirmed in 2017 with bipartisan support, both Republican and Democrats confirming her to the Court of Appeals back when that happened. But I would say that definitely qualifies her. If she is confirmed for the bench, she would be the only justice who didn't go to Harvard or Yale, but I think she could probably still hold her own, Michael, given her background.
Yeah, I think it's fine. We don't need to have every single one coming from Harvard and Yale. And as she said, she could show them a little bit about football. Who knows? All right, let me bring in Seth Berenzweig. And since it's your first time here now, let me get your impressions about what you saw today and what your overall impressions or first impressions were.
Well, first of all, I thought that Judge Barrett did a very good job. The first half of her opening statement, she used as an opportunity to personalize herself to the nation. And I thought that was very effective. She talked about her family, her children, then she rolled into her background. So I thought that was very effective as a way to really personalize herself and to let people know who she is. There's no question in my mind that it will become very clear, if not very clear already, that she is eminently qualified to be a member of the Supreme Court. And I also am really not a big fan of the Democrats' argument with respect to not going quick through this because, at the end of the day, I think that even Justice Ginsburg said that the president can appoint for 4 years and not for 3.5. So I understand the timing is peculiar and historically even closer to and through a part of the election as has occurred before. But one of the things that also struck me about the hearing today was there was just such grandiosity and grandstanding going on that it was really very disappointing. And it really happened a bit on both sides of the aisle. I really wouldn't try to point one side over the other. But I think that the Republicans in particular were trying to go into a preemptive attack, trying to anticipate that someone was going to attack her on her religion. I would be utterly stunned if that happens. And I thought a lot of the demagoguery and positioning was really a distraction. At the end of the day, I think that tomorrow will be more meat and more substance because there'll be less grandstanding and speeches, and we will really be getting into her judicial philosophy. And of course, that's going to be key and central.
Chanley, let me ask you, do we expect to hear much about her judicial philosophy? Because Justice Gorsuch really set the sort of game plan for these things now, where they don't want to talk too much about their philosophy because they don't get it locked in to any kind of, direction that they're going to go on any particular case. Now, do we expect that she'll actually have substantive answers in that direction?
I think you're right. You make a good point that it'll be limited. She's not going to, of course, tell the committee which way she would rule for a case concerning abortion or gun rights or whatever. She would definitely, though, I think it's fair game for them to ask her what her judicial philosophy is. She really already told them in her opening remarks today that her philosophy is that of her mentor, Justice Antonin Scalia, who was an originalist under the law. So she would look at the law and interpret words and terms as the founding fathers. That's how she would interpret the Constitution. So given that, I think they can guess where her rulings may go from there. But as far as giving a definitive answer as to how she may consider an issue or what she would be looking for or potential rulings she would make, that's something we see judges, they don't cross that line in a confirmation hearing, which really isn't appropriate because they're supposed to be fair and impartial and independent and not be influenced, or already have their mind made up. They're supposed to look at the law, look at the facts, and make their decision.
You know, Seth, you mentioned that there was some signposting going on by the Republicans regarding looking out for these questions about her Catholicism and how that might affect her judgeship. But isn't Catholicism fair game, considering it is such a central tenet to who she is, and it may affect some of her decisions in terms of how she goes about, let's say, abortion cases? So isn't it fair game? Not to say, of course, that someone who is Catholic can't be in office or, you know, things of that nature, but still, I think it's still fair game to go into that subject just a bit.
Well, it could be if it's done in a very delicate and precise way, where the focus of the question is really getting into the core of her judicial philosophy and what are the factors that she applies expressly and impliedly in terms of her judicial philosophy and her interpretation of the law and of the Constitution. But I think that although I agree with you that there may be a way to delicately explore that a bit, I think that the Democrats have to be, and they recognize that they have to be very, very careful here. They really don't want to have, chapter 2 of a Kavanaugh type situation where things went off the rails and the Republicans have already thrown a preemptive strike on that. If it's a question as it relates to religion, if it's a question that's based on religion as opposed to a question based on her judicial philosophy, I think that's going to be a problem. But certainly there are some very significant questions that relate to her background and her philosophy as it relates to life. She has made it pretty clear in her ideology that she believes that life begins at conception and goes through one's entire life cycle. You know, how does that fit into Roe and Planned Parenthood versus Casey? You know, these are some very significant issues and things that are going to play a big role and probably will relate to a number of the questions that we'll see raised in the hearing tomorrow.
Yeah, there's actually going to be a lot of terms we're going to hear as well. Let's look up one. I want to instruct our audience a little bit about some of the terms we're going to be talking about. One is strict construction. So let's call up a full screen here, and maybe we can read that for them and give them a sense of what that actually means. Now, strict construction or strict constructionism or original intent is a theory limiting the interpretation of legal and constitutional language to the literal meaning of the language at the time of passage. Now let's look at textualism. We'll hear that word thrown around a little bit as well. Textualism is going to mean it's a method of statutory interpretation whereby the plain text of the statute is used to determine the meaning of the legislation. Instead of attempting to determine statutory purpose or legislative intent, textualists adhere to the objective meaning of the legal text. All right, Seth, let me go back to you. Now, we've heard that she's an originalist, and originalists have a specific meaning, as I mentioned, and I want you to explain to our viewers who may not be as savvy on this what exactly that means, because it seems sort of counterintuitive. I'm going to look at the words of someone many, 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 many years ago, hundreds and hundreds of years ago, and make a determination as to what it means today. So how does that all work?
Well, it's a great question, and that really relates to some fascinating back and forth and analysis between the legal experts where how do we know exactly what the original intent was? And, you know, a lot of judicial philosophy hinges upon how things are interpreted. Judge Barrett is an originalist. She is a proud adherent of Justice Scalia. She is a former law clerk of Justice Scalia. And cut in the mold of Scalia, she is an originalist, which means that you don't go beyond the plain meaning of the text. You go into just the literal words, and that you can't treat the Constitution or some of these clauses or rights as some others might call it, a living, breathing document. So it's very interesting because Judge Gorsuch issued a very surprising decision just a few months ago as it relates to whether Title VII for employment cases, by its terms in talking about someone's sex, provides employment discrimination rights for transgender individuals. And that is not an originalist interpretation. He went beyond the clear words of the text in the statute. That was surprising to many analysts who are watching that in the Supreme Court. Judge Barrett will probably not go there, but that's really kind of an explanation as it relates to interpreting statutes and also interpreting the Constitution.
Yeah, I had a colleague who said to me something that always stuck with me. He said that originalism often leads to strange bedfellows, meaning, you see people like Gorsuch, you see people like Roberts, even Scalia from time to time found himself using that process and still ending up on perhaps what was more of a liberal side of things than most people or observers who are looking for a more conservative approach would have liked. All right, guys, please stick by. We're going to have a lot more to talk about, and we'll have more of Supreme Court nominee Amy Coney Barrett's opening statement when we return. So stick around for that.